പ്രിയമുള്ളവരെ, ദി ലോ ട്രസ്റ്റിൻ്റെ നിയമ ബോധവൽക്കരണ പ്രോഗ്രാമിൻ്റെ ഭാഗമായിട്ട് എല്ലാ മാസവും നടത്തി വരുന്ന സംരംഭത്തിൻ്റെ ഭാഗമായി ഇന്ന് വിഷുദിനത്തിന് വിഷുക്കണി എന്ന നിലയിൽ നമുക്ക് അനുഗ്രഹീതമായിട്ടുള്ള ഒരു വ്യക്തിയാണ് ഇന്ന് നമുക്ക് പ്രോഗ്രാമിന് കിട്ടിയിട്ടുള്ളത്. ഇതിൻ്റെ ചടങ്ങിൻ്റെ ആദ്യ ഭാഗമെന്ന നിലയിൽ ഈശ്വര പ്രാർത്ഥനയ്ക്കായി അഡ്വക്കേറ്റ് ലതാ സി നായരെ ഞാൻ ക്ഷണിച്ചുകൊള്ളു. ലത, തുടങ്ങാം. ഈശ്വര പ്രാർത്ഥന.
ശാന്താകാരം ഭുജഗശയനം പത്മനാഭം സുരേശം വിശ്വാധാരം ഗഗനസദൃശം മേഘവർണം ശുഭാംഗം ലക്ഷ്മീകാന്തം കമലനയനം യോഗിവിജ്ഞാന ഗമ്യം വന്ദേ വിഷ്ണു ഭവഭയകരം സർവലോകൈകനാഥം.
ഏറെ ബഹുമാന്യനായ അഡ്വക്കേറ്റ് ഡോക്ടർ വിനീത് കുമാർ സാർ, ട്രസ്റ്റ് സെക്രട്ടറി ശ്രീ അഡ്വക്കേറ്റ് പ്രേംകുമാർ, അദ്ദേഹം ഓൺലൈനിൽ വരുന്നുണ്ട്. ട്രസ്റ്റിൻ്റെ ട്രഷറർ അഡ്വക്കേറ്റ് മനു, ജോയിൻറ്റ് സെക്രട്ടറിമാരായ അഡ്വക്കേറ്റ് ശിവലാൽ, അഡ്വക്കേറ്റ് സുരേഷ്, അഡ്വക്കേറ്റ് വെങ്കടേഷ്, ട്രസ്റ്റിൻ്റെ ടെക്നിക്കൽ അസിസ്റ്റൻ്റായ അഡ്വക്കേറ്റ് ഷമീം, ഈ പ്രോഗ്രാമിൽ വെബിനാറിൽ പങ്കെടുക്കുന്ന എൻ്റെ പ്രിയപ്പെട്ട അഭിഭാഷകരെ, ഏറെ ബഹുമാന്യരായ ജുഡീഷ്യൽ ഓഫീസേഴ്സ്, ബഹുമാന്യരായ ട്രസ്റ്റ് അംഗങ്ങളെ, മറ്റു അഭിഭാഷക സുഹൃത്തുക്കളെ, ദി ലോ ട്രസ്റ്റ് 2012 രജിസ്റ്റർ ചെയ്തത്. ജസ്റ്റിസ് നഗരേഷ് സാറായിരുന്നു അതിൻ്റെ ഉദ്ഘാടനം നിർവഹിച്ചത്. അതിനെ തുടർന്ന് നിയമബോധവൽക്കരണ ക്ലാസുകൾ സംഘടിപ്പിക്കാറുണ്ട്. ഇതിനിടെ നമ്മളെല്ലാ വർഷവും മഹാനായ ജസ്റ്റിസ് VR കൃഷ്ണയ്യരുടെ പേരിൽ പുരസ്കാരം നൽകി വരുന്നു. 2010 മുതലേ തന്നെ ആൾ ഇന്ത്യ ബാർ എക്സാമിനേഷന് തയ്യാറെടുക്കുന്ന വിദ്യാർത്ഥികൾക്ക് സൗജന്യമായിട്ട്, നമ്മുടെ അഭിഭാഷകർക്ക് സൗജന്യമായിട്ട് പരിശീലനം നൽകി വരുന്നു. നിയമ സഹായങ്ങളും തുടങ്ങിയൊക്കെ ചെയ്തു വരുന്ന ഒരു സ്ഥാപനമാണ് ദ ലോ ട്രസ്റ്റ്. അതിനെന്താ സ്റ്റക്കായിരിക്കുന്നു? അതുപോലെ നിയമബോധവൽക്കരണ ക്ലാസിൻ്റെ പ്രോഗ്രാമിൻ്റെ ഭാഗമായിട്ട് ഇന്ന് വിഷുദിനത്തിൽ നമുക്ക് ഇവിടെ ഈ വിഷയത്തെക്കുറിച്ച് ബെയിൽ ആൻഡ് ട്രയൽ, ഒരു ജൂനിയർ അഭിഭാഷകനെ സംബന്ധിച്ച് പ്രത്യേകിച്ചും ബെയിലെടുക്കേണ്ടത് എങ്ങനെയാണ്, ട്രയൽ നടത്തേണ്ടത് എങ്ങനെയാണ് എന്നതിനെക്കുറിച്ചുള്ള പ്രായോഗികമായിട്ടുള്ള, അഭിഭാഷകർക്ക് ബെയിൽ എന്താണെന്നും ബെയിലിൻ്റെ വകുപ്പുകളും, ട്രയല്, സെഷൻസ് കോടതിയുടെ ട്രയൽ, മജിസ്ട്രേറ്റ് കോടതിയുടെ ട്രയൽ, സമ്മറി ട്രയൽ, ഇതൊക്കെ കുറിച്ചൊക്കെ തിയററ്റിക്കലായിട്ടുള്ള അറിവ് കുറച്ചൊക്കെ ഉണ്ടെങ്കിലും അത് കൂടുതൽ നമ്മൾ പ്രായോഗികമായിട്ടത് മനസ്സിലാക്കിയാൽ മാത്രമല്ലേ പ്രയോജനമാകത്തുള്ളൂ അഭിഭാഷകൻ എന്നുള്ള നിലയിൽ. അപ്പം അതിൻ്റെ ഭാഗമായിട്ട് ആ വിഷയത്തെക്കുറിച്ച് നിന്ന് കൈകാര്യം ചെയ്യുന്നത് തിരുവനന്തപുരത്തെന്നല്ല, കേരളത്തിലെ അറിയപ്പെടുന്ന ഒരു അഭിഭാഷകനാണ്, സീനിയർ അഭിഭാഷകനാണ് ശ്രീ വിനോദ് സാർ. അദ്ദേഹത്തിന് പല പ്രോഗ്രാമുകളൊന്നും ഉണ്ടായിരുന്നു വിഷുദിനത്തിന്. നേരത്തെ പറഞ്ഞ് തീരുമാനിച്ച കാര്യമായതുകൊണ്ട് അദ്ദേഹം ഇന്ന് കുടുംബവുമായി വിഷുവുമായി ബന്ധപ്പെട്ടൊക്കെ വിനോദത്തിന് പോകുന്ന അതൊക്കെ മാറ്റിവെച്ച് സാറ് നമുക്ക് വേണ്ടി ഇന്നിവിടെ വരാൻ തയ്യാറായത് വളരെ അദ്ദേഹത്തിനോട് വളരെയേറെ നന്ദിയുണ്ട്. 1993 അദ്ദേഹം അഭിഭാഷകനായി എൻറോൾ ചെയ്തത്. തിരുവനന്തപുരം കോടതിയിൽ അദ്ദേഹം പ്രാക്ടീസ് ആരംഭിച്ചു. അദ്ദേഹം ഇൻ്റർനാഷണൽ ലായിൽ LLM ബിരുദധാരിയാണ്. ഇൻഫ്ലുവൻസ് ഓഫ് ജനറ്റിക് ഫാക്ടേഴ്സ് ആൻഡ് ക്രിമിനൽ ബിഹേവിയർ എന്ന വിഷയത്തിൽ അദ്ദേഹം ഡോക്ടറേറ്റ് നേടിയിട്ടുണ്ട്. തിരുവനന്തപുരത്ത് പ്രത്യേകിച്ച് അദ്ദേഹത്തെക്കുറിച്ച് അഭിഭാഷകർക്കെല്ലാം സുപരിചിതമാണ്. നിരവധി കേസുകളിൽ അദ്ദേഹം സ്പെഷ്യൽ പബ്ലിക് പ്രോസിക്യൂട്ടറായി ആ കേസുകളിലെല്ലാം ഏകദേശവും ശിക്ഷിക്കപ്പെട്ടിട്ടുള്ളതാണ്. ഷാരോൺ വധക്കേസ്, ഹരിഹരവർമ്മ വധക്കേസ്, മര്യദാസൻ വധക്കേസ്, ആറ്റിങ്ങലിലെ ഇരട്ടക്കൊല കേസ് തുടങ്ങിയിട്ടുള്ള ധാരാളം നിരവധി കേസുകളിൽ അദ്ദേഹം സ്പെഷ്യൽ പബ്ലിക് പ്രോസിക്യൂട്ടറായി പ്രവർത്തിച്ചിട്ടുണ്ട്. ഞാൻ സമയം കൂട്ടുന്നില്ല. അപ്പോൾ ഇന്ന് ഈ ദിവസത്തിൽ, വിഷുദിനത്തിൽ, നമ്മുടെ ക്ഷണമനുസരിച്ച് അഭിഭാഷകർക്ക് ഏറ്റവും പ്രയോജനകമായിട്ടുള്ള ഒരു വിഷയത്തെ സംബന്ധിച്ച് അറിവ് പകരാനായി അദ്ദേഹം ഇവിടെ വരാൻ സന്മനസ് കാണിച്ചത് നിങ്ങൾക്ക് അദ്ദേഹത്തിനോട് വളരെയേറെ നന്ദിയുണ്ട്. ലാ ട്രസ്റ്റിൻ്റെ പേരിലും ഇവിടെ ഇന്ന് ഈ വെബിനാറിൽ പങ്കെടുക്കുന്ന എല്ലാ അഭിഭാഷകരുടെയും ജുഡീഷ്യൽ ഓഫീസറിനും വേണ്ടി ഞാൻ അദ്ദേഹത്തെ സ്വാഗതം ചെയ്യുകയാണ്. ലാ ട്രസ്റ്റ് സെക്രട്ടറി അഡ്വക്കേറ്റ് പ്രേംകുമാർ, ട്രഷറർ മനു തുടങ്ങിയിട്ടുള്ള ഭാരവാഹികൾ, അതുപോലെ ട്രസ്റ്റ് അംഗങ്ങൾ, അല്ലാതെയുള്ള നമ്മുടെ ലാ ട്രസ്റ്റുമായി സഹകരിച്ച് നിൽക്കുന്ന എല്ലാ അഭിഭാഷകരും, എൻ്റെ പ്രിയപ്പെട്ട എൻ്റെ വിദ്യാർത്ഥികളായിരുന്ന ജുഡീഷ്യൽ ഓഫീസേഴ്സും അതുപോലെ അഭിഭാഷകർക്കും ഞാൻ സ്വാഗതം അരുളുകയാണ്. അതുപോലെ ട്രസ്റ്റ് മെമ്പറായ ലത സി നായർ പ്രാർത്ഥനാഗാനം ആലപിച്ചതിനും ഞാൻ സ്വാഗതം അരുളുകയാണ്. ഞാൻ സമയം ദീർഘിപ്പിക്കുന്നില്ല. സാറിനെ ഈ നല്ലൊരു ക്ലാസ് അവതരിപ്പിക്കുന്നതിലേക്ക് വേണ്ടി സാറിന് ക്ഷണിക്കും.
So, respected Chairman of the Law Trust, Advocate Dr. P. Santosh Kumar, and all other office bearers of the Law Trust, and the participants who are attending this webinar online, all the participants, and other friends who are present here in this call. At the outset, I wanted to just express my sincere gratitude to Santosh sir, having just given me such a wonderful opportunity to address this August gathering, I would say online, though it's online as webinar. In fact, the services which is being imparted by the trust, the law trust, I know personally because many of the programs which were organized by the trust, I could participate also physically. And I've seen many of the legal luminaries were honored and the accolades were given, etc. And also the services which is being imparted to the society, especially the legal fraternity community. And why I'm just making a mention about this, because I'm also so happy that I could also be part and parcel of the service, which is indirectly, though, given to this lawyers community and the society as a whole. So when I was requested to just come and address you people on, because I just asked him whether just I'm a fit person to address this gathering, because just from the narrative, what I understand that the people who are or the participants of this webinar, in fact, they're all just well placed, much above me. So anyway, however, because when I was requested to just address on this topic, that is bail and trial, I was under the impression that the students who are all going to just listen to me. So please bear with me, the other senior officers and senior lawyers, and even the lawyers who are practicing, because only the simple way I thought I'll just put it across in the standard of the students. Anyway, just we will all discuss, and this I don't want to just prolong the deliberation. We will just go to the topic. I was given two topics. That is, one is bail, as Santosh sir has just explained. Bail and the different kinds of bail, and drafting, how it is to be drafted, and how it is to be presented before the court of law, etc. Just in a very simple fashion to understand. We know that this is we being lawyers. Whenever just we present a matter before a court of law, certainly just we expect a positive result. So, in what best fashion we can draft it, in what best way we can present it before the court, all these things are to be looked into. And we should have a little bit deep knowledge also about the law and the precedents and the latest Supreme Court or the High Court rulings, etc. This is the basic thing I wanted to just communicate with respect to the presentation of our bail, etc. Generally, for students, the other senior lawyers and the officers, please bear with me. So students may just have a just bird's view on this topic. What are the introductory factors of bail that can be looked into? Normally, when an accused person is arrested and brought before a court of law, his liberty is curtailed, is it not? So, what is to be ensured that he should also have some right, and he is also having some right, and he should be ensured with the liberty. That is during the trial, because before the court comes to a finding that he has committed an offense and he is guilty of an offense, and the conviction is to be ordered, certainly one principle is there that till the last moment wherein he is found guilty, he is presumed to be innocent. So certainly he is also having the right of liberty. So only to ensure that liberty, that bail provisions are incorporated in the law, in the provisions of law. So based on the presumption of innocence, that please just ensure that this is the legal concept. So naturally, at the same time, we shall not forget about the rights of victims. And the societal interest is also there, where the victim is certainly just affected with his right when an offense is committed against that individual. The societal aspects is also there. That interest is also affected with. That we should understand. Then there should be there should strike a balance between the right of the accused, thinking that he is an innocent till a court of law finds he is guilty, and also the societal rights. So there shall be a balance. There shall be a balance striken always. It should be done. So that is for the purpose. For that purpose, actually, the introductory aspects is there, and also it has been just emerged as the concept of bail. So this is a simple history and this thing. So then, at the same time, as I have just mentioned earlier, the victim is to be ensured with justice. This should also be there. So the court will always look into whether this person, the accused person who is brought before the court of law, is to be enlarged on bail at a particular stage, or the bail is to be rejected, etc. Then what is the responsibility of the lawyer, the accused, or what is the responsibility of the prosecutor? So certainly, because prosecutor is also just advocating the government for and on behalf of the government. At the same time, the defense lawyer is advocating for and on behalf of the accused. Here, naturally, the court is to decide upon the matter even on the bail application so judiciously. Is it not? So then what is the legal framework? That, of course, it goes without saying that legal framework is nothing but 1973 CRPC, of course, 436 to 450, that section. I need not, just because it is just before us earlier. Now, when the BENS has just come into effect, the corresponding provisions are there. I need not explain that. Of course, we'll just get through those provisions are also just in a very, not vivid fashion, but in a very short briefing way, we will just go through it. Then constitutional backing, we know that just we are all protected under Article 21 of the Constitution. That is the basic thing. Whenever just we talk about the bail, we are all just protected by the Article 21. Then how the bail works out? When a bail is moved before the court and the bail considers whether it is allowed or whether it is rejected. If it is allowed during the course of trial, certainly the accused is temporarily released. This is the concept, temporarily released. Because ultimately, whether he is to be just set at liberty finally or not, it all depends upon what? It all depends upon the judgment of the trial court. Is it not? So certainly this is a temporary phenomenon, that whether he is to be released or not, or the release of the accused is also a temporary one. Here, certainly at the time when the accused is released, allowing, if at all, just the court finds that in so many other particular circumstances under which he may have to be released, that also, because that I shall come into those areas later. But please do remember one thing: when the bail is granted, if court finds that he is entitled to be released on bail, in that situation, certainly there should be, because umpteen number of judicial decisions are pronounced by the Honorable Apex Court that it shall not be simply just set at liberty without any condition. There shall be some conditions. Certainly, subject to some conditions, he will be released on bail. why these conditions are being imposed, that should also it should also be kept in mind that though the accused is set at liberty temporarily, the court shall ensure that he is appearing or he will be appearing before the court for trial. So, in such fashion, depends upon the gravity of the offense and all that, the conditions will be imposed or fixed. Okay, this is the preliminary aspects about the bail. We have to just remember about it and just go through the other relevant provisions. We know that for the beginners, only for the beginners, I just remind you all that the types of bail are primarily four types. Which are they? Primarily, we know that regular bail is there, and also anticipatory bail is there, and a temporary or interim bail is there. You will not find the interim bail either in the provisions of CRPC or the BNSS, but due to the precedence which is being followed by the court sometimes, just we can see the interim bail which may be granted by many courts. How those circumstances that also we'll discuss. Then just coming to default bail. These are all the major types of four bails. It's being just practiced in the course of law. Okay. This is all preliminary things. I need not explain all these things to you, but of course, just as a formality, just I am just touching upon these subjects. So bear with me. Then what is regular bail? Goes without saying. Regular bail refers to the bail which is granted after the arrest was effected by the prosecuting agency or the investigating agency, as the case may be. Is it not? So, the regular bail, it can be granted under 437 of CRPC. The corresponding provision is 480 of BNSS. That will be entertained by, the bail application will be entertained by the magistrate. So that is also regular bail only. And as we are all aware of the fact that the anticipatory bail can be considered or even entertained only either by the Sessions Court or by the High Court of Kerala, or of course even the Supreme Court. Of course, invoking the concerned provisions. It is, of course, under 438 of CRPC only and a relevant provision of this BNSS also. Section 439 CRPC and 483 of BNSS, it is applicable to sessions judges and High Court of concerned state, the state. That is pertaining to anticipatory bail. And also one word about this, the usage of anticipatory bail. You won't find in either in the provisions of CRPC or in BNSS, you will not find the word anticipatory bail. This is, I'm just making mention about this particular thing for the junior lawyers or the beginners. Then what? Because one question we should just always think, when an anticipatory bail is filed before the court entertained that bail application and anticipatory bail is granted in favor of the petitioner accused. For juniors, I am just posing this question. Is it possible for the investigating agency to arrest him? Yes. It's a very big yes. Though anticipatory bail has been granted by the sessions judge or the High Court or even the Supreme Court, the accused person can be arrested. Why? Because the provision is very clearly mentioning, in case of the arrest effected by the investigating agency or the respondent, in that case, he may be released on bail. This is the word. So sometimes the juniors or even the students who are all just, listening my webinar conversation or even just otherwise, also they may be having a feeling that once anticipatory bail is granted, they cannot be arrested. It's not like that. The accused can be arrested, even if the anticipatory bail is granted. Only thing is that in pursuance of the direction given by the court, he shall be released forthwith as per the conditions imposed by the court. This is the one important aspect. And in this case, Nasser versus Union of India, you can also just, if at all, just wanted to note down the citation also, case C 410. High Court reiterated and relied upon the Supreme Court rulings. And also the state of UP versus Amarmani Tripathi's case, 2005, 8 SEC 21. So this is when we talk about the bail, these decisions are very, very important. And also Prasanta Kumar, Sarkar versus Ashish Chatterjee and another. These cases are when these judgments pronounced by the Supreme Court, certain very important it set certain policies in what fashion the bail is to be granted, under what circumstances the bail is to be granted, etc. Because mainly all these judgments, when we are just going through, you can find one thing. The court first has to look into the case, whether a prima facie case is there, whether there is any prima facie case. First, the court has to look into. Then, nature and the gravity of the offense against which the accused is either arrested or he is to be arrested. That when the anticipatory bail comes before that court. Then severity of the punishment. The danger of fleeing away, because the court has always some feeling that once the bail is granted, there is the risk of fleeing away. That means he will abscond. In such a situations, what is to be done? There actually the conditions or the important significance of conditions play a vital role. Okay, then the person against whom the charge is leveled against or the allegation is leveled against, his character can be looked into by the court, and also his behavior, position in the society, etc., are also very relevant facts as far as the court is concerned when the bail applications are concerned. Because apex court in Katina of decisions, these aspects were dealt with. Then the likelihood of repeating the offense, etc., all these things. And suppose if the court finds that there was some history of tampering with evidence or fleeing away from the clutches of law, then rejection of bail of the petitioner, his chance is more. That should also be looked into. So this is as far as the regular bail is concerned, and also anticipatory bail is concerned. We were talking about 438 of CRPC. Of course, the corresponding section of BNSS is 482. As we know that this is the concept of pre-arrest bail. So protection against the false implications, this is the only one solution for an accused person who is accused. That means it doesn't mean that he has committed the crime, accused. So if it is a false implication, certainly what is the remedy available for him? Approach either the Sessions Court or the High Court, as the case may be immediately, for getting his rights established, that he shall not be arrested. That is the thing. So I don't want to just go very deep into this anticipatory bail concept and all that. Now let us just have a very glimpse about this interim bail. What is interim bail? Interim bail, actually there is no provision either in BNSS or the CRPC. Interim bail, in certain occasions when the court was not in a position to take a decision imminently that either the bail application is to be rejected or to be allowed. But the court has to go very deep into the topic, the subject, and the allegations, or the prosecution could not give the reports properly. Or even at the same time, prima facie, the court feels that is it possible for him to commit this offense? Anyway, the court was not a position, or the court is not in a position to just enter into a clear decision whether bail is to be rejected or bail is to be allowed. In such situations, an interim bail, usually that is on the basis of precedents, not on the basis of invoking any particular provision of law. So interim bail is granted. So till that particular time, he will not be arrested by the investigating agency. Such bails is called the interim bail. That is in urgent situations also, when the accused is suffering from some disease, or he wanted to undergo some emergency treatment or surgery or something like that, an interim bail can also be granted. Of course, that is all normally it is being entertained by the high courts using the inherent jurisdiction of that court, not by sessions court. This is the major three types of bails. Now, just one more type of bail is left out to be deliberated upon, is default bail. What is default bail? Because default bail usually entertained by the court. Normally, when the investigation is to be conducted in 24 hours, but it is not possible always. In such situations, see, our law has very clearly stipulated that after a particular period, the accused cannot be detained. That is the thing. We cannot be detained unnecessarily just by prolonging the investigation under the guise of prolonging the investigation. It's not possible. He shall be released, because based on the severity of the offense alleged against the petitioner, if the punishment which is to be imposed by the court in certain offenses, up to 10 years, the period stipulated is actually 60 days, and above that, life imprisonment, and above, certainly it is 90 days. So within the 60 days or 90 days, as the case may be, if the investigation is not completed, it is the right of the accused to get himself enlarged on bail, and the court is expected to release the accused on bail, and it is not the discretionary power of the court to detain him. If he is offering the sureties, he shall be released on bail. That is the beauty of default bail. So section 167(2), I know that you have all gone through very detailed in depth. 167 subclause 2 of Criminal Procedure Code, of course, corresponding to 187 of BNSS now. It is, as I said, indefeasible right of the accused, mandatory, regardless of the merit of the case. And here actually one very celebrated judgment is to be noted by all, just for students especially, that is Hidendra Vishnu Thakur case. Hidendra Vishnu Thakur case was a state of Maharashtra, that is AR 1994. That is why I am telling that it is a celebrated decision, because it is, the position is settled in this regard, in this particular, because a lot of arguments were just being posed by others. Many people, that whether in such a situation the accused is to be enlarged on bail or not, and all that. But the court has made it very clear, right, if final report is not filed in time, whether it's 60 days or 90 days, as the case may be. And you can also just note down to 2023 2 KHC 663. That is ED versus Kapil Wadhwan's case. That is also very important judgment which has just come in favor of this. This is regarding bail under BNSS retains core principles always just in conformity with CRPC. There is no much difference at all. Then the timelines, just in conformity with the CRPC only. That is the thing. Then what is some slight difference is also there, just when you just go through very deep into BNSS compared to CRPC. Some digital process got introduced into uh, BNSS. That is very important because now just we are passing through here also today. I am addressing you on a webinar electronically, digitally. So this digital revolution is conspicuous in every spheres, including imparting of justice. So earlier, just we have not heard at all, just even only during the COVID time, that we all have argued the matter online before even sessions courts, even high courts, all just we have argued the matter online. So digital now the courts are just making it a point that almost all the trial proceedings, including trial proceedings, even the bail matters or even other applications are being dealt under the digital process. So in over a period of time, what we have to understand and we have to take cognizance of the truth that very slowly we will all become the part and parcel of the paperless administration of justice. This is going to be because we are now nowadays we are witnessing the smart courts, paperless courts everywhere. And now the courts have implemented, invoked the digital online e-filing process, and slowly the physical filing is being vanished. This is the truth. So here in bail matters also, it's being implemented. Especially if you just go through, there were no clear provisions. There were no clear provisions in criminal procedure code, but after the implementation of BNS, that is from 1st of July 2024, you can feel the difference just going through section 530, 531, 532. If you go through these provisions, the expedite, in order to expedite the matter, even these provisions will just certainly just aid the court as well as the legal community for arguing the matters online and get the even the digital judgments. So please just go through section 530, 531 and 532 also. So there you will find the e-filing, video conference hearing and e-orders in bail matters, etc. You will find there. So this is the nutshell of the bail, because basically we know the rule, that is a bail, and jail is an exception. So where this provision and this concept is accepted by our Indian judiciary, naturally everything will be taken into account, even the nature of accusations and the possibility of tampering with the evidence and the flight risking. What is the flight risking? It is nothing but the one word usually just the judiciary uses or the legal parlance is being used. Flight risking is the chance of fleeing away or just abscondence, etc. So that is with respect to the bail. Here for the juniors and even the students, one word about the drafting of bail. See, when an allegation is forthcoming against an accused person, how to draft the bail? I'm just explaining this is not on the basis of any documentary evidence or any documents as a case may be, but of course, out of my experience, I'm just sharing with you. See, usually when we just go through an affair, there will be some allegation against the accused. See, there will be some tendency for the petitioners while drafting the petition to mask certain things. Please don't do that. Whatever an allegation is raised, just while drafting the petition, the prosecution allegation, you can just put it in quotation. So it is not an admitted fact. It is in quotation. The prosecution allegation, whatever the allegation raised against the accused person, the petitioner has to, or the lawyer has to just see, he has to ensure that the same allegation which is just put forth by the prosecution is to be reduced into writing when the bail application is drafted. Facts of the case has to be narrated very clearly. Of course, then after going through the entire allegation against the accused, you have to just you have to just level the grounds against which the bail application is to be considered, bail is to be, or your submission is to be considered by the court. So the grounds are to be narrated very clearly under what are the rights, whether legally it is sustainable. That particular section, is there any whether the allegations constitute the offences alleged against the petitioner, etc., are to be very clearly narrated, and it shall be put in black and white as a ground. Then also, after completing you are drafting the beautiful way that the prayer is to be made, and the submission to the court, how it is to be submitted. Please don't argue in length, because normally the court is sitting after going through the provisions, I mean your applications. So in a very briefing manner, you have to submit, and in a very what do you call, gist of the allegations are to be submitted before the court, and the punching grounds are to be argued before the court so as to digest and so as to grasp very easily. And certainly, suppose if the false implication is your ground, and in what circumstances he was falsely implicated, just to try to impress upon the court. That is, and if he has no criminal antecedents, that is to be brought brought to the notice of the court. And also, he can just undertaking that he will cooperate with the investigation if the bail is granted, etc. And if at all any other relief you pray, and the conditions can also be imposed by the court which deem fit by the court. All these things you can submit before the court. This is a submission. These are all the usual submissions to be made before the court. So clear facts and highlights regarding the legal rights, and address the prosecution objections in reply if necessary. These are all the major what do you call, the stages which you may have to just undergo when the bail application is put forth before the court of law for argument. Then from practical angle, for deciding upon the matter, the court is to be enlightened with these aspects. Certainly, liberty of your client is to be ensured. That is your responsibility. Certainly, you shall never forget, when you argue the matter before the court, you shall never deviate from your ethical principles and duty to the court. That is also very important, because we are having some commitment towards the petitioner, that is our client or the accused. At the same time, we are also part and parcel of the society. And certainly, while just keeping up the dignity and the ethical duty to the court should also be maintained. And whatever you submit before the court, it shall be very effective, and it shall be put in effective fashion. These are all the major aspects to be looked into by a beginner as a criminal lawyer, especially when dealing with bail applications. And a beginner in criminal law, practicing criminal law, 3 rulings, please go through very deeply. Number 1 is Gurbaksh Singh Sibia versus State of Punjab, Siddharam Satlingappa Maitreya versus State of Maharashtra, Arnesh Kumar versus State of Bihar. See, as far as the first judgment which I have referred to, that is Gurbaksh Singh Sibia case, that is in 1992, SEC 565. See, the court, it's a landmark judgment on anticipatory bail. See, suppose reasons to believe is very important thing. It's mandatory, and the objective is satisfaction of the court. The court has made it very clear, and no relief on vague allegations. Don't expect. The court has made it very clear. Purpose of anticipatory bail is also very clearly just enshrined in that. Court must apply its mind. FIR not necessary for applying pre-arrest bail. Because many people are under the impression that when an anticipatory bail application, the pre-arrest bail used to be argued before a competent court of law. Suppose if the prosecutor says that no case is registered, very easily the petition can be closed, no case registered. But in this respect, please remember one thing. In this Gurbakshan Singh Sisbia's case, the court has made it very clear that for considering an anticipatory bail application, FIR is not mandatory. Even without an FIR, bail application can be considered and even considered and granted. This is a very important thing, and that is the important significance of Gurbaksh Singh Sibbia's case. Remedy available after FIR, but before the arrest. These are all the major principles laid down by the Honorable Apex Court in this case. Then the next one is for beginners, Siddharam Satlingappa Matre versus State of Maharashtra 2011 in 1 SCC 694. That is, again, the Apex Court reaffirmed and expanded the principles laid down in Gurbaksh Sibbia's case. What are the personal liberty under Article 21 of the Constitution of India? It got highlighted like anything. Unjustly deprived of liberty through arbitrary arrest, contempt. Then also not to continue till the conclusion of the trial. So if at all there's where the accused person who is detained in custody, if he is entitled to be released on bail, that relief shall be ensured by the trial court. Then anticipatory bail for limited or short duration is deprecated. So these are all the major principles laid down by the Honorable Apex Court in that case. As far as the Arnesh Kumar state versus State of Kerala, you may be remembering that the 41 days notice. So that is corresponding is 35.3 of BNSS. Here, that is also a landmark judgment of the Honorable Supreme Court, because actually though that arose when a 498A matter has come up before that court, whether he is to be arrested or not, the court has made it very clear that simply the arrest is wherever the cognizable offense is reported, immediately the person is arrested. Here, because of the arrest itself, sometimes many cases the family relations got shattered. Sometimes there would have been the chances of unifications. But of course, once the husband is arrested and just put behind bars, is there any chance of then reunification? Then subsequently, the chance is very remote. Considering so many these all societal aspects, the court has made it very clear that, see, in such situations where the punishment is below 7 years, one notice can be issued. That is 41A. That is as far the CRPC is concerned. And the corresponding provision is 35.3. There, the arrest is not mandatory. And the only thing is that the arrest can be exercised by the investigating agency where the conditions imposed by the court is violated by the accused. In such situations, even by accepting the bond at the station itself, he can be released on bail. So in such situation, that is the significance and importance of Arnesh Kumar versus State of Bihar. So this certainly, why this? Here also, the court has given significance on Article 21 and 22. That is the very beauty of it. So helps prevent mechanical and arbitrary arrest, not alone confining to 498A cases. This was made applicable to all cases where the punishment is up to 7 years of imprisonment. Strengthens the accountability of police, and that means investigating agency and judiciary also. So this is the major judgment, and the recent trends and the directions of the High Court are also there. So actually the liberal approach is being made by the judiciary here. And the official memorandum, probably you might have seen in one, just around, I think it's a 13/3/2026, our Honorable High Court has issued an official memorandum in consonance with the judgment pronounced by the Honorable Apex Court, that is 2026 KHC 6114. See, this is very important, that the judgment pronounced by the Honorable Supreme Court, that is Ziba Khan versus State of UP, 2026 KC 6114, based on which the Honorable High Court of Kerala just pronounced this official memorandum HCKL 9590/2025 D1 dated 13/3/2026. Few days back, the Honorable High Court. What is that? See, all the antecedents of the accused and the severity of the punishment and the character of the accused. Was there any conviction or is there any process pending against the petitioner? All these aspects are to be very clearly mentioned in the application, because one form has been prescribed by the court and that should be annexed with the bail application. If that form is not annexed along with the bail application, the bail will not be granted, even if the petitioner or the accused is entitled to be released on bail. Though, on the basis of which it cannot be rejected, but it will not be entertained. So, the court has clearly stated that it is a curable defect. So, now please do remember that each and every bail application, either before the Honorable High Court of Kerala or Supreme Court, or even the Sessions Court, or even the Assistant Sessions Court, or the High Court, the Magistrate Courts, this is now mandatory. Earlier, we can just make one of the narration in the bail application itself that no other bail application is pending either before this court or before any other court, including Honorable High Court of Kerala. Once the vouching on the application is there, that would have been sufficient. But now it is not sufficient by virtue of this particular direction given by the Honorable High Court of Kerala in consonance with the judgment pronounced by the Apex Court. So that is to be remembered. So all the junior lawyers who are now filing the application before the courts. This is the very, very important thing. Because if at all any coercive step it is there that is to be disclosed, and affidavit requirement is to be there, then purpose of the direction duty of the court to ensure that all the details which was sought for by virtue of the format is complied with and or furnished with. So these are all the important things as far as the bail is concerned. So, in short, in our jurisprudential system, the bail just to strike the balance between the liberty and justice to the victims also. And just considering all these aspects, we can come to a conclusion that though CRPC was replaced by BNSS, there is no much, the sea changes are not there, but of course, it continues the core principles of CRPC. This is the important thing. Okay, these are all the few words I have to speak about bail. I'll just take a 5 minutes break, just 5 minutes break, then we'll start with the next topic, that is trial. Okay. Off ചെയ്യുന്നുണ്ടോ? Welcome back. Let us just have a glimpse on the topic criminal trial. Of course, there is no much difference between the CRPC and BNS with respect to the provisions while dealing with the trial aspects. There is no much difference. Of course, slight difference is there that I'll just brief on those areas when we touch upon that area. Okay. Now, the topic which I am just going to deal with, that is also, please bear with me as far as the seniors are concerned or other officers are concerned, only for the beginners or students, how the trial to be approached with, and what is the meaning, and what are the steps of trial, types of trial, and role of prosecutor, and also defense counsel. See, we know that the as far as a trial is concerned, when a judicial officer is sitting as a judge to decide upon a matter, certainly representing the government, there is prosecutor, and representing the defense, either the accused himself or represented by a lawyer. So this is a simple thing which we all know in a court, in a criminal trial. And what are the legal steps and the legal provisions which help the lawyers, help the prosecution, and help the court to prove the fact whether the accused is guilty or is innocent? These are all the major areas which we have to throw light upon, and that we will be discussing. So, in that, for how, what is the trial? Trial in a very, very, very short manner, we can explain that it is nothing but an avenue for the judiciary, prosecution, or the defense, as the case may be, to prove his innocence or his guilty. And the tools which are provided to the lawyers and the prosecution, chief examination is there during trial, cross-examination is there when a witness is just put on the box, and a re-examination is there. All these aspects are there. These provisions, it's all just, codified by the provisions of law, either in CRPC or BNSS, as the case may be, because we know that any crime committed prior to July 1st of 2024 will be dealt with under the provisions of CRPC. Thereafter, first onwards, of course, under the provisions of BNSS. This is the nutshell I am just wanted to. And some judgments pronounced by the Honorable Supreme Court and High Court also will be dealt with on relevant provisions of law when we are dealing with the concerned topic. Just for introduction, I have to say something about the law. Actually, the procedure of criminal law in India, it's a work with the substantive law, not alone the BNS, and also how the evidence is to be tendered, how the evidence is to be adduced. Even the investigating agency are also expected to follow some instructions or a certain, they follow the provisions of Evidence Act or BNSS, the BSA. And those aspects we'll be discussing. See, what is the meaning of criminal trial? I said it is a judicial process, as I said, to determine the guilt or innocence. To start with, begins after framing of charge. So the first step, framing of charge by the court in a trial. So begins after framing of charge. So only after framing of charge, the trial begins. What is framing of charge? The court, just put it across the accused that whether you have committed this offense or not, because I took cognizance after going through the documents produced by the prosecution and other material objects and the records produced before the court. And prima facie, I feel that you have to undergo the trial and that will be explained. Did you commit this offense? So, one chance is given to the accused either to plead guilty or to just face the trial. Face the trial. So an opportunity is given. So this is actually framing of the importance and the role of framing of charge is being dealt with. And now, what is a system which we follow in India is nothing but adversarial system. See, adversarial system is nothing but the two counterparts are there. That is prosecution on the one side and the other side the defense. So this is a simple meaning just to explain for the beginners, adversarial system. And the burden of the prosecution is always to prove the offense beyond reasonable doubt. In certain occasions, it is even, you can just go by that. Even this principle, you need not confine on this principle. Why? Because certain other provisions are there. For example, even in IPC or the BNS as a case, maybe the concerned provisions, some the offenses, it is actually the provision itself mandates that the presumption is to be drawn by the court unless the contrary is proved by the defense. So the legal presumptions, even in vigilance, the Prevention of Corruption Act cases, Section 20. Just incidentally, I am remembering of prevention of corruption. I think it is a bounden duty of the defense to prove. Otherwise, the court has to presume that the accused is guilty. And also in POCSO cases, the presumption is there. So, except these in very few cases or even few laws, the general principle is that the burden of the always it is burden of the prosecution that beyond reasonable doubt it shall be established. The guilty shall be proved by the prosecution. This is the concept normally in being followed in India. And what are the major stages of a criminal case? What are the major stages? We know that the genesis of a criminal case, once a cognizable offense is reported to the station house officer on the basis of a first information statement. FIR is registered and sent to the court. So that is the first and foremost stage, first stage, I would say. Then on the basis of this first information statement and FIR, the investigation immediately begins. That is the second stage. After the investigation, if the investigating agency find that the accused shall be prosecuted for the offense committed, then a final report will be filed before the concerned magistrate of the the jurisdictional magistrate, we say that. So naturally, on the basis of the final report, the court has to take a cognizance of the offense. What is the meaning of cognizance or taking of cognizance? Because on the basis of all the records now available before the magistrate or the court concerned, the court is examining, after perusal and examining the entire documents furnished by the prosecution. If the court is satisfied, just to satisfy that this is a prosecutable case, so taking of or examining and understanding the gravity of the offense, and the offense will certainly liable to be tried, etc. So taking that process is called taking of cognizance. Once the cognizance is taken, that is then next framing of charge is a formal step. under section 251 of BNS corresponding to 228 of CRPC, you can say. Then you can, because I'm talking about the sessions trial, then we'll go for trial. This is the next step. After the trial, if the court finds that accused is guilty, certainly a judgment will be pronounced convicting the accused. If the court finds that the prosecution has not failed or the benefit of doubt is to be given to the accused in such situations, a judgment of acquittal will be pronounced. So judgment. Of course, either the prosecution or the accused, as the case may be, can approach the next appellate court for appeal. That is also there. This is the major stages of criminal trial. And also key BNSS provisions related to this FIR, of course, I need not explain because that is also, you can go through it. I don't want to just waste much time on that. That's FIR 173 BNSS corresponding earlier provision 154 of CRPC. The investigation, we know that begins immediately 177 till 193 BNSS section earlier provisions, after 156 till 173, just till the filing of final report. And the final report, otherwise, in a common parlance or the among lawyers, we call that charge sheet. I can tell you there will be no word in CRPC or BNSS, as the case is, the word charge sheet. But in many judgment, including the judgment pronounced by the apex court, we can see the charge sheet. But it is common usage, common parlance. Charge sheet. Charge sheet is always referred to final report under section 173 of CRPC or as far as 193 of the BNSS. So, this is just for information. Charge sheet, my advice is that for the junior lawyers, kindly don't use charge sheet. But whenever just you wanted to, or you'd like to refer to the report filed by the police before the court for requesting to take cognizance, that report, that is called a final report. Always use the word final report instead of charge sheet. This is my just suggestion. Then what are the major types of criminal trial? Types of criminal trial. Goes without saying that sessions trial and also warrant trial, summons trial and summary trial. Then how the sessions trials takes place for grave offenses, normally sessions offenses which are being enlisted in the concerned provisions as well as even the table, you can find that is sessions offenses, sessions trial. That is from section 248 till 259 of BNSS, which was earlier the STL law 225 till 237 of CRPC. And the steps, how the steps of a sessions trial. First of all, opening of a sessions case by the prosecutor. The prosecutor has to open the sessions trial after considering the entire prosecution documents. He has to address the court stating that the charge will lie against the accused person. And once the court is convinced that the accused need not be discharged, then charge will be framed. Then thereafter, a schedule will be fixed for taking evidence, prosecution evidence. After completing the prosecution evidence, defense evidence, and also judgment. In between, actually, there shall be an opportunity be given to the accused for what? For explaining all the incriminating evidence so far as forthcome against the accused. This is the situation. This is the steps for as far as a defense, the trial is concerned. In sessions trial. Warrant trial, some slight difference is there. That is, offense is punishable by a term not exceeding 2 years. That is warrant trial. And that is two kinds of reports. In the sense, the warrant trial can be initiated against an accused person either on the basis of a police report or against a complaint. That we call it a complaint case. This is the difference. But as far as the sessions trial, it is different. But warrant trial, either it can be on the basis of the police report, and otherwise it is on the basis of a complaint. In common parlance, we say that it is a private complaint. So section was 261 to 273 of BNSS, and section 238 till 250 CRPC. That is the corresponding provisions. As far as the summons trial is concerned, it is less serious offences, not exceeding 2 years. So where the court finds that the summons trial is to be initiated, the simplified procedures are to be adopted by the court. It is very clearly provided under section 274 till 282 of BNSS, which was S12 section deals with 251, that is CRPC, and with 251 till 259. There, one difference is that in still the warrant case, actually formal charges would be framed by the court. But as far as the summons trial is concerned, no formal charge, but the plea would be recorded by the court, that's all. No, in writing, there will be no charge framed by the trial court. As far as the summary trial is concerned, that is for minor offences, we call that is petty offences. Just for quick disposal, the provisions are very clearly provided in 283 to 288 of BNSS. That is corresponding to 260 till 265 of CRPC. You can go through that. There is no much deliberation is required for that. And there are also significant steps, as I have told you earlier. After opening of the sessions trial, charge is framed and the opportunity is being given to the accused for plead guilty or not. Then evidence, once it is taken by the court, first from the prosecution, thereafter from the defense if available. Then of course, I told one provision 313 of CRPC, which is otherwise now just corresponding to 351B of BNSS, because giving an opportunity to the accused to explain about the incriminating circumstances forthcome against him when the prosecution evidence was let in. Then after that, a defense evidence, if available, can be let in by the defense. After letting the defense evidence, if available, then the next step is the argument. The first argument shall be initiated by the prosecution. And once the prosecution completes the argument, certainly the next opportunity is for the defense to argue. And of course, some legal clarification wherever it is required, the prosecutor is getting again one more opportunity to explain. After completing the final hearing, the judgment will be pronounced. These are all the major events or the steps which are to undergo in a trial court, especially when it is dealt with by the sessions. So framing of charge, as I have already explained, that is section 251 BNSS corresponding to 228 of CRPC. So prima facie, if there is no prima facie case, this is pertaining to wherever the court finds that the charge is to be formal, charge is to be framed against the accused. These are all the steps to be undergone. But if the court finds that under section 227, after considering the entire documents and even the other hearing both the sides, the accused as well as the prosecutor as the case may be, if the court finds that there is no sufficient materials to frame the charge against the accused, means the accused is to be discharged. So that is the important step. So whatever I have just earlier stated, that is only where the court found that there are sufficient materials to frame the charge against the accused. Okay. Now let us just throw some light on the area how the evidence is taken. The first prosecution evidence is to be let in. The next opportunity is available for the defense to let in. How the prosecution evidence begins. As far as the defense, the sessions trial is concerned, 231 CRPC is a real provision for commencement of the taking of evidence by the prosecution. Corresponding provision for in section 254 of BNSS. You can see how the evidence is being taken. You know that there are two kinds of evidence is being let in for deciding upon the matter by the trial court. That is, number one is oral evidence. That is through witnesses. Of course, documentary evidence are also being let in through the witnesses only. So, documentary evidence, oral evidence through the witnesses is being let in. And there will be some another kind of evidence is also just being let in, that is identification of material objects. So suppose, for example, a grave offense is committed by an accused and it is under trial before the court. The court finds that how this particular occurrence was done. So, for example, a stabbing incident. An accused person stabbed a person to death. In such a situations, it is very important that the weapon used by the accused for committing the offense. So, certainly, if the weapon is not before the court and if the weapon is not recovered, certainly there may be slight the weakness on the side of the prosecution. But wherever the sufficient explanation is forthcoming before the court of law, that whether the tampering of evidence even by destroying the weapon, etc., has been proved by the prosecution, certainly that can be wiped off. So, but I'm telling you that the weapon or the material object is also very important in many cases where the murder or any grave offenses like attempt to murder, etc., is being tried before the trial court. Then let us just go to the other other part. I told you the opportunity given to the accused under section 313 CRPC corresponding to 351 of BNSS. That is explaining. He is explaining because each and every incriminating evidence forthcome before the trial court would be put to the accused for explaining. It is not under oath. It is not at all under oath. But he can even keep mum. Even he can keep mum. But an adverse inference cannot be drawn. That is different thing. But of course, the apex court has decided otherwise also on in some judgments. Now, after explaining, after putting the questions, he is given, the accused is being given another opportunity to explain at last. Certainly, even in writing, a statement can also be given under section 313 corresponding to 351 of BNSS. So, normally, the defense lawyer gives what is his defense in the last statement or through the oral submission of the accused. Sometimes the accused will just confine only with one word, ഞാൻ നിരപരാധിയാണ്. ഇത്രയും മാത്രം ചിലപ്പോൾ പറഞ്ഞുകൊണ്ട് നിർത്താറും ഉണ്ട് മിക്ക കേസുകളിലും. നോക്കൂ, അത് കഴിഞ്ഞതിന് ശേഷം ട്രയലിൽ വരുന്ന വളരെ പ്രധാനപ്പെട്ട ഒരു ഭാഗമാണ് ദ നെക്സ്റ്റ് the stage is that defense evidence. That is under section 256 of BNSS corresponding to section 233 of CRPC in sessions trial. So defense evidence is optional. It is not mandatory that after the prosecution evidence, the defense shall let in the defense evidence. No, it is optional. It is, he can take a decision. The lawyer or the accused himself can take a decision whether he should let in evidence or not to disprove the charges leveled against him. Please do remember that. Then, one more opportunity during the course of defense evidence. A very important section is there, that 315 of CRPC corresponding to 353 BNSS. What is that? The accused he himself can get into the box, witness box, and depose in favor of him, just to disprove the charges. That is dealt with under section 315 corresponding to 353. See, here one important thing is to be remembered by a defense lawyer, that wherever he opts that the accused is getting into the dock, witness box, please do remember that when a simply submitting before the court that the defense would like to, or the accused himself want to just let his evidence in support of his case or disprove his case, the court will not allow. But it shall be in writing. It shall be in writing, but not by the defense lawyer, but he himself write. In the sense, he himself has to file an application. പ്രതിയുടെ ഇതായിട്ട് ഒപ്പിട്ട ഒരു അപേക്ഷ കോടതി മുമ്പാകെ നേരിട്ട് ഫയൽ ചെയ്താൽ മാത്രമേ പ്രതിക്ക് ഒരു സാക്ഷിയായിട്ട് കയറി മൊഴി പറയാൻ കഴിയൂ. അല്ലാതെ മറ്റ് സാധാരണ രീതിയിൽ പലപ്പോഴും ഇപ്പോൾ ഈവൻ നമുക്ക് ഒരു ബെയിൽ ആപ്ലിക്കേഷൻ ഫയൽ ചെയ്യുന്ന സാഹചര്യത്തിലാണെങ്കിൽ പോലും ദ അക്യൂസ്ഡ് ഈവൻ ഹി ക്യാൻ ജസ്റ്റ് authorize his lawyer to sign for and on behalf of the petitioner, accused petitioner, to file a bail application. But here, when he opts to let in evidence for and on his behalf that he wanted to testify before the court, it shall be in writing. It shall be in writing and signed by him. So this is an important thing. 315 or 353 mandates that. Mandates. So please do remember. See, after completing the entire formality, after the hearing, as the case may be, I said the prosecution as well as the defense, then final judgment would be pronounced by the trial court under section 335 of CRPC corresponding to 258 of BNSS. There the court, after assimilating the entire facts, circumstances and evidence, the court will come to a conclusion whether the accused is to be acquitted or to be convicted. So this is the finality of the judgment, the trial. Some tips I would like to just share with you about the roles to be played by the prosecutor and the defense lawyer, as the case may be, while a trial takes place before a competent court of law. And there are also some practical solutions and practical way of approaching a defense case and also prosecution, because I have some experience as a special public prosecutor in many sensational cases and also as a defense lawyer. And I could find that certain very, very important steps which a prosecutor takes before the court plays a vital role. Sometimes, you may be having a feeling that the prosecutor is always expected to confirm that the accused is to be put behind bars. No, that is not the duty of a prosecutor. The prosecutor is vested with the responsibility to help the court, convince the court to impart justice. This is the prime thing. So not to secure conviction at all costs, at any cost, I should see that the accused is put behind bars. That is not the responsibility of the prosecutor. But what we are seeing, in many cases, the prosecution always just think that suppose if it ended in acquittal, in such cases, the prosecutor is belittled. No, it's not the thing. If there's a prosecutor, he helps the court to find the truth. That is the real victory of the prosecution and a real victory of justice. You can, I would like to remind you our some Bar Council of India rules, Part 6, especially Rule 13, not to suppress any fact before the court. It's very clearly stated. And you have to present the truth before the court. So, the duty of the prosecutor to the court to help the court find the truth. Especially in Shiv Kumar versus Hukum Chand case, in 1999 7 SEC 467, the court held prosecution actually, in that particular case, one particular principle has been evolved. It has been decided, other than the matter which I have dealt with, because I said it is the responsibility of the prosecutor, because Part 6, Rule 13, Bar Council of India rules not to suppress any matter. This is applicable not alone for the prosecution. It is actually any lawyer, any counsel, any advocate, for that matter, this Rule 13 is important. It states that it is only the counsel. Prosecutor is actually just wearing the gown for the government or the prosecution agency. He is advocacy or advocating the government. Similarly, the defense is advising his client. So, any advocate or any counsel appearing for his party is expected to adhere with the Rule 13 of Bar Council of India rules. And this is one aspect. Now, see, the court in this particular case, Shiv Kumar versus Hukum Chand, what the court has held, Honorable Apex Court, the prosecutor alone to prosecute, not any private person. Because the matter has been adjudicated upon before the court, that it is the right of a person to prosecute. The court has not upheld that contention at all, and held very clearly that it is the business and the transaction between the government and the judiciary to prosecute, not by the private person. That is important. So, private person, see, you may be remembering that in CRPC there is a provision 301. But in that provision, a person can file wakalat. But what he can do, he can help the prosecutor. He can help the prosecutor, assist the prosecutor. But he cannot conduct any examination or even argue the matter before the court of law in supporting the prosecution. The very limited role alone is there by virtue of section 301 of CRPC. So that has been made very clear in this particular case, the Shiv Kumar versus Hukum Chand case. Okay. Similarly, a lot of other responsibilities are vested with the defense counsel. Not alone the prosecution. We are all having some duty. We have a lot of responsibility and duty to our client, accused. And also, we have duty to the court. See, why we are appointed, for what purpose we are appointed, the defense counsel is appointed as a defense counsel by the accused, just to canvass his case before the trial judge. Just to canvass what he has to submit before the court. That is being spoken to by the counsel, the advocate, in a legal sense. Because he is an expert. He is a legal expert, and using his legal expertise, he is authorized by the party to unfold the case of the accused before the trial court. So in that respect, he has to be loyal to his party. So these are all the important things. That is the reason why we say that the communication between the accused and the lawyer, always the lawyer, the advocate, the defense counsel is expected to keep the confidentiality. So the provision is there. Even the accused is protected by virtue of the provisions of our Indian Evidence Act and the BSA. So in one case, I would like to just make a mention. The duty of the defense counsel, when we discuss about one case, is very important. You have to study that case for beginners. That is Usainara Khatun versus State of Bihar. It is a public interest litigation case, PIL case. What is that? Actually, that is some happenings pertaining to the long incarceration in jail for thousands and thousands of accused persons without being trial held. They were actually imprisoned. Even after crossing the normal imprisonment period or the punishment period of imprisonment, even thereafter, crossing that minimum or maximum period of imprisonment, the trial was not taken place. And they were continuing the imprisonment. When the matter was adjudicated upon before the Honorable Apex Court in the form of a public interest litigation against the Bihar government, the Supreme Court, after perusing and looking into the entire aspect, really literally shocked. And thousands of the accused were ordered to be set at liberty. Because that is injustice. That is case 1981 SEC 98. That is Usainara Khatun versus State of Bihar public interest litigation case. So on the basis of the Article 21 of our constitution, so they were released. Thousands were released. So this is actually in that judgment, the Supreme Court has enshrined the duty of the defense counsels or even the duty of the counsels. Probably you might have all heard that one speech of the greatest criminal lawyer Ramjit Milani, while he is addressing a gathering of junior lawyers. He was speaking to the lawyers that, see, you were all just aspirants to become good lawyers. He was telling that anyone who study laws can become a lawyer. But I don't want you to become simply lawyers who are studying law and who knows laws. That is only a mason or a carpenter while constructing a very big building. You be an architect, be an engineer to build the nation, not alone just by studying the law. So a lawyer should always be just committed to the society. So you be an architect instead of a mason, a carpenter. This is the words of a great Ramjit Milani. So while we are just doing the part and parcel or just playing our own role in the society, as a human being, as a lawyer, as a social animal, just like this particular trust, law trust, doing this service to the humanity, our responsibility is also, we should always just rethink that are we doing justice to our conscience. So that is why the Supreme Court has in this particular case said it is the responsibility and duty of each and every lawyer to rise to the occasion and do justice to your conscience by imparting justice to the society. This is what our Ramjit Milani, the great lawyer, has also stated. So assist justice. Maintain your integrity for that and help the court find justice. Do justice. So don't mislead the court at all. This is the basic things a lawyer should certainly just keep up and follow in trial. Certainly we have some duty to the client also because we are being paid. It's not as a charity we are doing. Certainly we are paid. We must be loyal to our party, keeping the confidentiality. And for that, in order to help the court find justice, you must be competent. You should learn law very clearly. You must be very firm in making your submission without misleading the facts before the court. Those things for a criminal lawyer, actually, it is the basic requirements. These are all the things. And also you should earn certain experience in conducting the trial, certain things, examination of witnesses. You should learn from your experience, not from the classroom. You have to swim into the water, dip yourselves, then you swim. It is not simply possible to study how to examine, either to conduct a chief examination or to conduct a cross-examination. You have to watch how the seniors are cross-examining or conducting the chief examination, how they are tackling a witness, because how to tackle a witness to bring out the truth. Sometimes the witness may lie in the court. Sometimes the witness who is expected to adhere with the statement which he has already just given to the investigating agency may just deviate from his earlier statement and say falsehood. In that case, how the prosecutor should bring out the truth. All these things are actually an art. I would say that it's an art. We should just practice that. See, some tips I would like to just give along with this theoretical aspect. See, what is examination in chief? Because any party, whether it is a prosecutor or the defense lawyer, when he is calling his party as a witness, that is examination in chief is to be conducted. As for you may guess, please go through 137 and 138 of Indian Evidence Act corresponding to section 142 and 143 of BSA. There you can find the order of examination, how it is to be just carried out, how the first chief examination and the other party can conduct the cross-examination. Then if at all just any new evidence has been spoken to by the witness or some ambiguity has usurped into the cross-examination or brought out in the cross-examination, certainly the party who called the witness has the opportunity to conduct a re-examination. That is also to be learned. Here, when the chief examination is to be conducted by a party before a court, the very important thing is no leading question is to be put. That is a basic thing. What is leading question? For beginners and juniors, leading question. I know that each and everyone who is listening to me know, but still, as a formality, I am telling you, leading question is nothing but suggesting the answer and making the witness to speak about yes or no. Making the witness to say the answer yes or no. കേരളത്തിന്റെ തലസ്ഥാനം തിരുവനന്തപുരമല്ലേ? ഉത്തരം എന്താണ്? അതെ. കൊല്ലം അല്ലല്ലോ? അല്ല. അല്ലെന്നോ അതെയെന്നോ പറയുന്ന ഒരു ഉത്തരം ഏത് തരത്തിലിട്ടാലും കേരളത്തിൻ്റെ തലസ്ഥാനം ഏതാ എന്ന് ചോദിച്ചാൽ ഉത്തരം വരുന്നത് ഏതാണ്? തിരുവനന്തപുരം. ഒരു മോഡൽ നമ്മളിത് പറയുന്നു. ഇങ്ങനെ ഒരു ആൻസർ സജസ്റ്റ് ചെയ്യുന്നതാണ് ലീഡിങ് ക്വസ്റ്റ്യൻ. അതൊരിക്കലും ഒരു ചീഫ് എക്സാമിനേഷനിൽ നടത്താൻ പാടില്ല. നടത്താൻ പാടില്ലേ എന്ന് ചോദിച്ചാൽ ചെയ്യാം. എപ്പോ? ചില സാഹചര്യങ്ങളിൽ. എങ്ങനെ? അതായത് നമ്മൾ ഇപ്പോൾ ഒരു ഇൻട്രൊഡക്ടറി ആയിട്ട് ഒരു ഫസ്റ്റ് ചോദ്യം ഒരു സാക്ഷി കൂട്ടിക്കയറി കഴിയുമ്പോൾ വിറ്റ്നസ് വെൻ ഈസ് ഇൻ ദ ബോക്സ് യു ക്യാൻ ജസ്റ്റ് പുട്ട് എ ക്വസ്റ്റ്യൻ. ആദ്യത്തെ ഫസ്റ്റ് ചോദ്യം, നിങ്ങൾ ഈ കേസിലെ മരണപ്പെട്ട ആളിൻ്റെ ഭാര്യയാണല്ലേ എന്ന് ചോദിച്ചാൽ ഉത്തരം എന്താണ്? അതെ എന്ന് ചോദിക്കുന്നത് അവിടെ പെർമിസിബിളാണ്. കാരണം അൺഡിസ്പ്യൂട്ടഡ് ആയിട്ട് ഉള്ള ഒരു ഫാക്റ്റാണ്. പിന്നെ കൂടാതെ ഇൻട്രൊഡക്ടറി ആയിട്ട് ബിഗിൻ ചെയ്യുന്നതിലേക്ക് വേണ്ടിയിട്ടുള്ളതാണ്. അത് പെർമിസിബിളാണ്. പിന്നെ ഡിഫൻസ്, പ്രോസിക്യൂട്ടറെ സംബന്ധിച്ചിടത്തോളം ആണെങ്കിൽ ഡിഫൻസിനെ സംബന്ധിച്ചിടത്തോളം ആണെങ്കിൽ പ്രോസിക്യൂട്ടർ ഒരു ഒബ്ജക്റ്റ് ചെയ്യാത്ത ഒരു ക്വസ്റ്റ്യൻ, സാധാരണ അതായത് ഡിസ്പ്യൂട്ട് ഇല്ലാത്ത ഒരു കാര്യത്തിനെ നമുക്ക് ചീഫ് എക്സാമിനേഷനിൽ നമ്മൾ ചോദിച്ചാൽ അതും കോർട്ടിന് പെർമിറ്റ് ചെയ്യാം. ലീഡിങ് ക്വസ്റ്റ്യൻ ആയിട്ട് പരിഗണിക്കത്തില്ല. അത് ലീഡിങ് ക്വസ്റ്റ്യൻ ആണെങ്കിലും അത് പരിഗണിക്കാം. ഇങ്ങനെയുള്ള സാഹചര്യങ്ങൾ ഒഴിച്ചാൽ ഒരു കാരണവശാലും ലീഡിങ് ക്വസ്റ്റ്യൻ പെർമിസിബിൾ അല്ല. ഈ ഒരു കാര്യം നമ്മൾ എപ്പോഴും ശ്രദ്ധിക്കണം. അത് നമ്മൾ ഈ 137 138 ഇന്ത്യൻ എവിഡൻസ് ആക്ട് കറസ്പോണ്ടിങ് ടു 142 ആൻഡ് 143 ഓഫ് BSA നിങ്ങൾ വായിച്ചു നോക്കിയിരിക്കണം ഉറപ്പായിട്ടും, ബിഗിനേഴ്സിനെ സംബന്ധിച്ചിടത്തോളം. പിന്നെ ഓർഡർ ഓഫ് ചീഫ് എക്സാമിനേഷൻ, എക്സാമിനേഷൻ ഓഫ് ദ വിറ്റ്നസ് നമുക്കറിയാം. ചീഫ് എക്സാമിനേഷൻ, ക്രോസ് എക്സാമിനേഷൻ, റീ എക്സാമിനേഷൻ, ഇത്രയും കാര്യങ്ങളാണ് പറയുന്നത്. ഈ എക്സാമിനേഷനിലൂടെ ഒരു 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 നല്ല ഒരു എക്സാമിനർ എന്ന് പറയുന്നത്, വെദർ ഇറ്റ് ഈസ് ചീഫ് എക്സാമിനിങ് ഓർ ഇറ്റ് ഈസ് ക്രോസ് എക്സാമിനിങ്, അതിനകത്ത് ഒരു പർട്ടിക്കുലർ കേസിൻ്റെ ആ കേസിൻ്റെ ആ വിറ്റ്നസ്സിൻ്റെ ഇമ്പോർട്ടൻസ് അനുസരിച്ച് ആ ഇമ്പോർട്ടൻസ് എന്ന് പറഞ്ഞാൽ എന്താണ്, ആ വിറ്റ്നസ്സിൻ്റെ റോള് അല്ലെങ്കിൽ ആ വിറ്റ്നസ്സിൻ്റെ പോയിൻ്റ് ടു ബി പ്രൂവ്ഡ്, ആ പോയിൻ്റ് ടു ബി പ്രൂവ്ഡിൽ വളരെ പ്രധാനപ്പെട്ട എല്ലാ ഫാക്ട്സും ബ്രിങ് ഔട്ട് ചെയ്യുന്ന തരത്തിലായിരിക്കണം ചീഫ് എക്സാമിനേഷൻ നടത്തേണ്ടത്. ദാറ്റ് ഈസ് എ വെരി ഇമ്പോർട്ടൻ്റ് ആസ്പെക്ട് thing in the in the trial. Please don't think that the chief examination shall be done in verbatim as in the case of 161 statement or the previous statement of the witness. No, not necessary at all. Then how? Suppose without having any contradiction of the previous statement and without just making any additional information, additional evidence which may be otherwise just put across by the defense as omission, which may amount to contradiction subsequently. ആ വരാത്ത രീതിയിൽ വളരെ കൃത്യമായിട്ടും നമ്മൾ ആ വിറ്റ്നസ്സിനെ കൊണ്ട് പറയിക്കേണ്ടുന്ന കാര്യങ്ങൾ മാത്രം കോർട്ടിലേക്ക് ആവശ്യമുള്ള കാര്യങ്ങൾ പറയിക്കുക. പക്ഷേ പറയിക്കേണ്ടതെല്ലാം പറയിച്ചിരിക്കണം. പ്രധാനപ്പെട്ട ആ സാക്ഷിയുടെ പോയിൻ്റ് നമ്മൾ പറയിപ്പിക്കാൻ വിട്ടുപോയാൽ പ്രോസിക്യൂട്ടർ ആ സാക്ഷിയിലൂടെ വരേണ്ടുന്ന പോയിൻ്റ് വന്നില്ലെങ്കിൽ ഫെയ്റ്റലായിരിക്കും. അതാണ് നമ്മൾ ശ്രദ്ധിക്കേണ്ടത് ചീഫ് എക്സാമിനേഷൻ്റെ സമയത്ത്. സോ വി ഹാവ് ടു ബി വെരി കെയർഫുൾ ഹൗ ടു ബ്രിങ് ഔട്ട് ദ മേജർ പോയിൻ്റ് ഓഫ് ദാറ്റ് പർട്ടിക്കുലർ വിറ്റ്നസ്. ദിസ് ഈസ് എ പ്രാക്ടിക്കലായിട്ടുള്ള ഒരു എൻ്റെ അനുഭവത്തിൽ നിന്നുകൂടി ഞാൻ പറയുകയാണ്. നമ്മളത് വളരെ സൂക്ഷ്മതയോടെ കൈകാര്യം ചെയ്യേണ്ടതാണ്. നോക്കൂ, ക്രോസ് എക്സാമിനേഷനിൽ നമ്മൾ ഈ ലീഡിങ് ക്വസ്റ്റിനെ സംബന്ധിച്ചിടത്തോളം അങ്ങനെ ഒരു ഭാഗമേ ഇല്ല എന്ന് മാത്രമല്ല, ലീഡിങ് ക്വസ്റ്റ്യൻസ് പെർമിസിബിളാണ്. അത് ഓപ്പോസിറ്റ് പാർട്ടി ഇപ്പോൾ ഡിഫൻസ് കൊണ്ടുവരുന്ന ഒരു വിറ്റ്നസ്സിനെയാണ് ചീഫ് എക്സാമിനേഷൻ ഡിഫൻസ് ലോയർ ചെയ്ത് കഴിഞ്ഞാൽ അല്ലെങ്കിൽ പറഞ്ഞു കഴിഞ്ഞാൽ മറുഭാഗത്ത് പ്രോസിക്യൂട്ടറാണ് ക്രോസ് ചെയ്യുന്നത്. അവിടെ ഏത് തരത്തിലുള്ള ലീഡിങ് ക്വസ്റ്റ്യൻസും ഇടാൻ കഴിയും, അത് അലൗഡാണ്. നോക്കൂ, ഈ ലീഡിങ് ക്വസ്റ്റ്യൻസും ക്രോസ് എക്സാമിനേഷൻ എന്ന് പറയുന്നത് ഏറ്റവും വളരെ പ്രധാനപ്പെട്ട ഒരു ടൂളാണ്. എന്തിനുള്ള ടൂളാ? വാട്ട് ഫോർ ഇറ്റ് ഈസ് ടു ബ്രിങ് ഔട്ട് ദ ട്രൂത്ത്. നോക്കൂ, അത് നമ്മുടെ ക്രിമിനൽ ട്രയലിലെ ഏറ്റവും പ്രധാനപ്പെട്ട ഒരു ആയുധമാണ് ഡിഫൻസിൻ്റെ അല്ലെങ്കിൽ മറുഭാഗത്തിൻ്റെ. ഒരു വിറ്റ്നസ് കൂട്ടിൽ കയറി പറയുന്നത് സത്യമാണോ അതോ കള്ളമാണോ എന്നുള്ളത് നമുക്ക് മറുഭാഗത്തിന് തെളിയിക്കാനുള്ള ഏറ്റവും പരമപ്രധാനമായിട്ടുള്ള ഒരായുധമാണ് ക്രോസ് എക്സാമിനേഷൻ. അതിൽ ആ ക്രോസ് എക്സാമിനേഷനിലൂടെ ആ സാക്ഷി പറയുന്നത് കള്ളമാണ് എങ്കിൽ കോടതിയെ തീർച്ചയായിട്ടും സത്യം മനസ്സിലാക്കുന്നതിലേക്ക് വേണ്ടിയിട്ട് ഡിഫൻസ് ലോയറുടെ ഡ്യൂട്ടി അല്ലെങ്കിൽ പ്രോസിക്യൂട്ടറുടെ ഡ്യൂട്ടി ആണ് ക്രോസ് എക്സാമിനേഷനിലൂടെ ചെയ്യേണ്ടത്. അതിലേക്ക് വേണ്ടിയിട്ട് ഒരു ക്രോസ് എക്സാമിനേഷൻ ചോദ്യത്തിൽ സാക്ഷിയെ നമുക്ക് അയാളുടെ ക്രെഡിബിലിറ്റിയെ, അയാളുടെ ക്യാരക്ടറിനെ ഒക്കെ ഒരു പരിധിയിൽ അകത്ത് നിന്നുകൊണ്ട് ക്രെഡിബിലിറ്റിയെ ഇമ്പീച്ച് ചെയ്യാനുള്ള പരമപ്രധാനമായിട്ടുള്ള ഒരു അവകാശം ഈ ക്രോസ് എക്സാമിനർക്കുണ്ട്. പക്ഷേ അത് സാക്ഷിയെ ഇൻസൾട്ട് ചെയ്യുന്ന തരത്തിലേക്കോ അല്ലെങ്കിൽ വേറെ അയാളെ ഇറിലവൻ്റ് ക്വസ്റ്റ്യൻസ് ഇട്ട് ഹരാസ് ചെയ്യുന്നതിലേക്കോ അല്ല. അവിടെ വരുമ്പോൾ കോടതിക്ക് ഇടപെടാം. പക്ഷേ ഒരു കേസിന് റിലവൻ്റായിട്ട് വരുന്ന തരത്തിലുള്ള ക്രോസ് എക്സാമിനേഷനിലൂടെ കേസിൻ്റെ സത്യാവസ്ഥ സാക്ഷിയിലൂടെ പുറത്തു കൊണ്ടുവരാൻ സഹായിക്കേണ്ടത് ആ ക്രോസ് എക്സാമിനറുടെ ഡ്യൂട്ടിയുമാണ്. അതിന് എല്ലാവിധ സഹായവും സപ്പോർട്ടും കോടതിയിൽ നിന്നും ലഭിക്കും. അതാണ് ഇതുവരെയും എൻ്റെ ഈ 33 വർഷത്തെ എക്സ്പീരിയൻസിൽ നിന്ന് എനിക്ക് കിട്ടിയിട്ടുള്ളത്. സോ യു ക്യാൻ നർച്ചർ ദി ടാലൻറ്റ് ഓഫ് ക്രോസ് എക്സാമിനേഷൻ ടു പ്രൂവ് ദ ട്രൂത്ത്, ബ്രിങ് ഔട്ട് ദ ട്രൂത്ത്. അതിലേക്ക് വേണ്ടിയിട്ട് ഇപ്പോൾ നമുക്കറിയാം, ഇപ്പോൾ ഈ ക്രെഡിബിലിറ്റി നമുക്ക് എങ്ങനെയൊക്കെ ആണ് അയാൾ ക്രെഡിബിൾ വിറ്റ്നസ് ആണോ ഇല്ലേ എന്നുള്ളത് കൊണ്ടുവരാൻ കഴിയുക. ക്രോസ് എക്സാമിനേഷനിൽ നമുക്കറിയാം, he might have given his previous statements, he might have given his previous statement before, sworn in statement before the magistrate. അപ്പം 161 CRPC-യിൽ പറഞ്ഞിരിക്കുന്ന തരത്തിലോ അല്ലെങ്കിൽ 164 CRPC-യിൽ പറഞ്ഞിരിക്കുന്ന പ്രൊവിഷൻസോ, അതായത് കറസ്പോണ്ടിങ് പ്രൊവിഷൻ 180 ആൻഡ് 181 ഓഫ് CRPC, BNSS കൊടുത്തിരിക്കുന്നത്, 183 ഓഫ് BNSS കൊടുത്തിരിക്കുന്നത് അറിയാം. ഇവിടെ നമുക്ക് ഈ പ്രീവിയസ് സ്റ്റേറ്റ്മെൻറ്റിനെ കോൺട്രഡിക്റ്റ് ചെയ്തുകൊണ്ട് തന്നെ ഒരു പരിധിവരെ ഈ സാക്ഷിയുടെ ആ ക്രെഡിബിലിറ്റിയെ നമുക്ക് ക്വസ്റ്റ്യൻ ചെയ്യുന്ന തരത്തിലേക്ക് അല്ലെങ്കിൽ പ്രൂവ് ചെയ്യുന്ന തരത്തിലേക്ക് ബ്രിങ് ഔട്ട് ചെയ്യാനായിട്ട് നമുക്കൊരു വലിയൊരു ആയുധമാണ് ക്രോസ് എക്സാമിനേഷൻ. അതിൽ ശ്രദ്ധിക്കേണ്ട എന്താണെന്ന് വെച്ച് കഴിഞ്ഞാൽ, ഇപ്പോൾ 161 സ്റ്റേറ്റ്മെൻറ്റ് അല്ലെങ്കിൽ BNSS-ൻ്റെ ആണെങ്കിൽ 180 സ്റ്റേറ്റ്മെൻറ്റ്, ഇൻവെസ്റ്റിഗേറ്റിംഗ് ഏജൻസി അല്ലെങ്കിൽ പോലീസ് റെക്കോർഡ് ചെയ്തിരിക്കുന്ന സ്റ്റേറ്റ്മെൻറ്റ്, ആ പ്രീവിയസ് സ്റ്റേറ്റ്മെൻറ്റ് നമുക്ക് കോൺട്രഡിക്റ്റ് ചെയ്യാനായിട്ട് ഉപയോഗിക്കാം. അവിടെ നമ്മൾ വളരെ ശ്രദ്ധിക്കേണ്ടുന്ന ഒരു കാര്യം, ഈ പലപ്പോഴും എങ്ങനെയാണ് പ്രീവിയസ് സ്റ്റേറ്റ്മെൻറ്റിനെ കോൺട്രഡിക്റ്റ് ചെയ്ത് ഈ സാക്ഷിയുടെ ക്രെഡിബിലിറ്റിയെ നമ്മൾ ഇംപീച്ച് ചെയ്യുന്നത് എന്നുള്ളത് പ്രാക്ടിക്കലായിട്ട് എക്സ്പീരിയൻസ് ചെയ്തെടുത്ത് ആ ഒരു ടാലൻറ്റ് സ്വായത്തമാക്കേണ്ടുന്നതാണ്. ബിഗിനേഴ്സായിട്ടുള്ള ലോയേഴ്സ് പലപ്പോഴും അത് ശ്രദ്ധിക്കാതെ പോയി കഴിഞ്ഞാൽ നമുക്ക് ഈ കോൺട്രഡിക്ഷൻ ബ്രിങ് ഔട്ട് ചെയ്യാനും അതുപോലെ തന്നെ ഈ പറഞ്ഞിരിക്കുന്ന ഒമിഷൻസ് ബ്രിങ് ഔട്ട് ചെയ്യാനും നമുക്ക് പിന്നീട് അത് പഠിക്കാൻ കഴിയാത്തൊരവസ്ഥ വരും. അതുകൊണ്ട് ആദ്യമേ തന്നെ അത് പഠിക്കണം. എങ്ങനെയാണ് പഠിക്കേണ്ടത്? ഞാനൊരു അതിൻ്റെ ഒരു ചെറിയ ഒരു വിശദീകരണം തരാം. ഇപ്പോൾ 161 സ്റ്റേറ്റ്മെൻറ്റിൽ അല്ലാന്നുണ്ടെങ്കിൽ BNSS-ലെ 180 സ്റ്റേറ്റ്മെൻറ്റിൽ ഒരു സ്റ്റേറ്റ്മെൻറ്റ് ഓൾറെഡി പോലീസിന് കൊടുത്തിരിക്കുന്നു. ആ സ്റ്റേറ്റ്മെൻറ്റ് ഡിഫൻസ് ലോയർക്കും പ്രതിക്കും അതിൻ്റെ കോപ്പി കിട്ടും. സോ ആഫ്റ്റർ ഗോയിങ് ത്രൂ ദി എൻ്റയർ സ്റ്റേറ്റ്മെൻറ്റ്, he started his cross-examination on the witness on that particular point, just against the deposition he has already made in consonance with the 161 statement or the 180 statement, as the case may be. Then one particular point the defense lawyer asked in the cross-examination, one particular point he asked and bring out a fact which is absolutely contradictory with the 161 or the 180 statement. Okay, absolutely contradictory. So then what is the next step? That is important thing. The next important thing you have to remember that this particular statement which he has deposed before the court contradictory to the previous statement is to be brought out and recorded. How? That is to be, first he has to cross-examine on that point without showing the statement to him. Without showing the statement to him, you have to put that statement to the witness as envisaged under section 145 of Indian Evidence Act corresponding to 148 of BSA. Then after putting the statement to him, if he still just stick on and cling on that contradictory statement, then that is to be requested to the court to just mark that statement which is contradictory to the previous statement. So suppose if the witnesses speaks lot of contradictions or contradictory statements or depositions before the court, which is very material, which will cut at the root of the prosecution, means he is telling lie. The court has to take a presumption that he is speaking lie, not truth. So this is very important. So in that case, the Tahsildar's case, you may please study for the beginners how, especially paragraph number 13 and 19, if my memory is correct, paragraph number 13 and 19, vividly it is described how the contradiction is to be brought out from the previous statement. This is in fact applicable to 164 statement also. That is the statement given to the magistrate. So this is actually contradictions. Then again, I'm just coming to the another point, that omissions. See, the omission may also tantamount to contradiction, material contradiction, as envisaged under the provisions of section 162. So that can also be used while arguing the matter before the trial court, that this witness cannot be believed. In that case, certainly benefit of doubt goes to the accused. In that case, the court can find that the prosecution fails or failed to prove the prosecution case, the charge. In that case, it will ultimately end up in an acquittal. So sometimes in that fashion, the accused may get justice. So certainly this particular tool can be used in the cross-examination. So the contradiction and omission. The omission, that is also very clearly stated in Tahsildar's case, that the ruling also, please go through AR 1959. It's very the settled case. 1959 SC 1012. I am just telling for the juniors and the beginners in the so the Tahsildar's case is a celebrated case, and that is without just studying and without following this case, no criminal lawyer can practice as a criminal lawyer. This is the truth. So especially you can go through section para number 13 and 19 of Tahsildar's case. Tahsildar Singh versus State of UP, AR 1959, SC 1012. So this is the contradiction and omissions. Omission is the statement just almost opposite, you can say, because he has stated new things. He has stated new things while deposing before the court. Then certainly the defense lawyer asked him, have you stated this particular facts which you have now deposed before the court to the investigating agency when the statement was recorded by him? He says, yes. If he says yes, or if he says he doesn't remember, in that case also, then you can say that is not seen recorded. That is not seen recorded in your statement. It may amount to omission. So, if it works out as an omission and that omission tantamount to a material contradiction as provided under section 162, then also the defense can use what? As a big tool to impeach the credibility of the witness. So this is very important as far as a defense lawyer is concerned when he is exercising his very important right of cross-examination. This is what I have to just submit about this. Then for a fair trial, we know that the defense lawyer as well as the prosecutors always just confirm, and the fair trial is to be ensured. That is the fact. So almost our time is up. So I'm just touching. Please do remember that our Sahira Sheikhs versus State of Gujarat case, you may be knowing it, the best bakery case, the Gujarat കലാപത്തുമായിട്ട് സംബന്ധിച്ചിട്ടുണ്ടായത്. അതായത് ബീഹാറിൽ നിന്ന് മഹാരാഷ്ട്രയിലേക്ക് സുപ്രീം കോർട്ട് ആ കേസ് ട്രാൻസ്ഫർ ചെയ്തിട്ട് ഫെയർ ട്രയൽ എൻഷുർ ചെയ്യുന്നതിലേക്ക് വേണ്ടിയിട്ട് അവസരം വരെ കൊടുത്ത കേസാണ്. ഓർമ്മയുണ്ടോ? അത് തീർച്ചയായിട്ടും ബിഗിനേഴ്സ് ഒന്ന് വായിച്ച് പഠിച്ചിരിക്കേണ്ടുന്ന ഒരു കേസ് തന്നെയാണ്. കാരണം അതിനകത്ത് ഭയപ്പാടോടുകൂടി ഒരിക്കലും ഒരു സാക്ഷിക്ക് മൊഴി പറയാൻ കഴിയാത്തൊരവസ്ഥ ഉണ്ടാകരുത് എന്നുള്ളത് എൻഷുർ ചെയ്തിട്ട് അങ്ങനെയാണ് ഈ വിറ്റ്നസ് പ്രൊട്ടക്ഷൻ സ്കീമും ബാക്കിയുള്ള എല്ലാം വന്നിരിക്കുന്നത്. അപ്പം ഞാൻ കൂടുതലായിട്ട് ഒന്നും പറയുന്നില്ല ഇനി. ആക്ച്വലി ഒരു ബാക്കിയുള്ള എല്ലാ എത്തിക്സും മെയിൻറ്റെയിൻ ചെയ്തുകൊണ്ട് ഒരു ക്രിമിനൽ ലോയർ പ്രാക്ടീസ് ചെയ്യുകയാണ് എന്നുണ്ടെങ്കിൽ നമ്മുടെ വളരെ ഈ ലോകം തന്നെ അല്ലെങ്കിൽ ഇന്ത്യ കണ്ട മഹാരഥന്മാരായിട്ടുള്ള ക്രിമിനൽ ലോയേഴ്സിനിടയിൽ അവർ രാം ജത്മലാനി അദ്ദേഹം പറഞ്ഞതുപോലെ തീർച്ചയായിട്ടും സമൂഹത്തിന് നമുക്ക് ആർക്കിടെക്ട്സ് ആകണം. അല്ലാതെ കട്ടയെടുത്ത് വയ്ക്കുന്ന അല്ലെങ്കിൽ ഒരു ആപ്പ് മാത്രം അടിക്കുന്ന അല്ലെങ്കിൽ ഒരു കമ്പ് രാഗി എടുക്കുന്ന വ്യക്തി മാത്രമാകാതെ സമൂഹത്തിനെ രാജ്യത്തെ ബിൽഡപ്പ് ചെയ്യുന്നതിലേക്ക് ഒരു അഭിഭാഷകന്, ഏത് ലോയേഴ്സ് ആണെങ്കിലും, പ്രത്യേകിച്ച് ഒരു ജസ്റ്റിസിന് വേണ്ടി വാദിക്കുന്ന ലോയർക്ക് ഉത്തരവാദിത്വം ഉണ്ട് എന്ന് പറഞ്ഞുകൊണ്ട് ഞാൻ ഈ വലിയ ഒരു അവസരം തന്ന ഈ നമ്മുടെ ഈ ലാ ട്രസ്റ്റിനെ അങ്ങേറ്റം ഒരു നന്ദിയും കൂടെ ഞാൻ അറിയിച്ചുകൊണ്ട് വാക്കുകൾ നിർത്തുകയാണ്. നമുക്ക് ഏതാനും മിനിറ്റുകൾ നമുക്ക് വീണ്ടും എന്തെങ്കിലും ചോദ്യങ്ങൾ എന്തെങ്കിലുമൊക്കെ ഉണ്ടെങ്കിൽ സംശയങ്ങളുണ്ടെങ്കിൽ നമുക്ക് ഡിസ്കഷനിലേക്ക് പോകാം.
ഡൗട്ട്സ് ഉള്ളവർ ദയവായി ആദ്യം അവരുടെ വീഡിയോ ഓൺ ചെയ്യുക. വീഡിയോ ഓൺ ചെയ്തതിന് ശേഷം മൈക്ക് അൺമ്യൂട്ട് ചെയ്തിട്ട് സബ്ജക്റ്റ് ഓറിയൻറ്റഡ് ആയി ക്വസ്റ്റ്യൻസ് ചോദിക്കാവുന്നതാണ്, 1 by 1 ആയിട്ട്. മൈക്ക് അൺമ്യൂട്ട് ചെയ്തിട്ട് സംസാരിക്കാം.
Sir, generally in sessions trial, prosecution shall establish the case on the details ആയിട്ടല്ലേ പറയുന്നത്. Prosecution shall explain the contents of the cases എന്നല്ലേ പറയുന്നത്.
അതെ അതെ, പ്രോസിക്യൂഷൻ.
പക്ഷെ പ്രാക്ടിക്കൽ സെൻസിൽ അങ്ങനെയാണോ സാർ നടക്കുന്നത്? വി ഫൈൽ എ മെമ്മോ ആൻഡ് വക്കാലത്ത് ആണെന്നല്ലേ കേസ് സ്റ്റാർട്ട് ചെയ്യുന്നത്.
പ്രോസിക്യൂട്ടർ ഷാൽ ഓപ്പൺ അപ്പ് ദ കേസ് എന്ന് പറഞ്ഞാണ് തുടങ്ങുന്നത്. അത് അതിനെപ്പറ്റി ചോദിച്ചത്.
ബട്ട് പ്രാക്ടിക്കലി പ്രാക്ടിക്കലായിട്ട് നടക്കുന്ന സെൻസ് എന്ന് പറഞ്ഞാൽ നമ്മൾ ബേസിക്കലി വക്കാലത്ത് ആൻഡ് മെമ്മോ ഫയൽ ചെയ്യും, അക്യൂസ്ഡ് ഈസ് ഓൾറെഡി ഓൺ ബെയിൽ ആണെന്നും പറഞ്ഞ് അങ്ങനല്ലേ കേസ് സ്റ്റാർട്ട് ചെയ്യുന്നത് പ്രാക്ടിക്കൽ സെൻസ് കൺസിഡർ ചെയ്യുമ്പോൾ?
അല്ല, നമ്മൾ ഇപ്പോൾ ഈ 225 CRPC കറസ്പോണ്ടിങ് ടു BNS നോക്കിയാലും പ്രോസിക്യൂഷൻ ഷാൽ ഓപ്പൺ ദ കേസ് എന്ന് പറഞ്ഞാൽ തുടങ്ങുന്നത്. അതായത് ഓൺ ദ ബേസിസ് ഓഫ് ദ റെക്കോർഡ്സ് അവൈലബിൾ ബിഫോർ ദി കോർട്ട്, ദറ്റ് ഈസ് ഫർണിഷ്ഡ് ബൈ ദി പ്രോസിക്യൂഷൻ, ആൻഡ് ഓൾസോ certainly just after hearing the defense. So first the prosecutor shall open the case. So in section it is very clearly mentioned. അത് വെച്ചിട്ട് പ്രോസിക്യൂഷനാണ് തുടങ്ങേണ്ടത്, പ്രോസിക്യൂട്ടറാണ് അത് ഓപ്പൺ ചെയ്യുന്നത്. അങ്ങനെയാണ് സെക്ഷനിൽ വളരെ ക്ലിയർ ആയിട്ട് കിടക്കുന്നത് തന്നെ. സോ യു ക്യാൻ ഗോ ത്രൂ ദാറ്റ് പ്രൊവിഷൻ. ഓക്കെ, അതുകൊണ്ടാണ് അങ്ങനെ ഞാൻ പറഞ്ഞത് പ്രോസിക്യൂഷൻ ഷാൽ ഓപ്പൺ അപ്പ് ദ കേസ് എന്നുള്ളത്. മറ്റത് ആക്ച്വലി നമ്മൾ പ്രാക്ടിക്കലായിട്ട് കോടതിയിൽ അങ്ങ് തുടങ്ങുന്നത് അങ്ങനെയാണ്. പക്ഷേ നിയമത്തിൽ ഡിഫൻസ് അല്ല തുടങ്ങുന്നത്, പിന്നെയോ പ്രോസിക്യൂട്ടർ ഷാൽ ഓപ്പൺ ദ കേസ്. ട്രയൽ അല്ലാതെ പ്രൊസീജിയേഴ്സ് അല്ല തുടങ്ങുന്നത്, ട്രയൽ. ഓക്കെ,
ഇനി ആരെങ്കിലും ഡൗട്ട്സ് ഉള്ളവരുണ്ടോ? ഉണ്ടെങ്കിൽ വീഡിയോ ഓൺ ചെയ്ത് ഒന്ന് സ്വയം ഇൻട്രൊഡ്യൂസ് ചെയ്തിട്ട് ഡൗട്ട്സ് ചോദിക്കുക.
Sir, it's a wonderful class. And
hello.
Doubt unda?
Sorry to disturb you, sir.
Please.
First of all, Vineeth sir, thank you very much for a wonderful session. Sir, I just wanted to ask that you have given a lot of examples, relevant citations to all these sections, which has been, really useful. So I'm a student of law and a first year student. So my syllabus is set to cover this BNS. Actually, we have only dealt with BNS as of now. So I'm not able to properly, put these citations in a coherent model, actually. So it would be grateful if you or your office could, properly summarize and give these citations which you have given along with those relevant sections. So it will be really helpful.
That will be done. So absolutely, it will be done. And just since our Santosh sir is also listening to your request,
Okay.
I just make arrangements that all the citations which I have just now cited,
Okay.
refer to here, it will be enlisted and it will be handed over to this office. You may please just
Okay.
contact him and collect it. Thank you so much for just asking for it.
Thank you so much, because while listening to you and sir taking the notes, so we didn't want to split the attention between the both. That's the reason why we skipped it. Otherwise, we would not have disturbed you.
Thank you,
Thank
sir.
you so much.
I
Thank
shall
you.
arrange for communicating or
Thank you, sir.
the relevant sessions.
Thank you so much. Thank you. That's all, sir.
സർ നമസ്കാരം സർ. വിനീത് സാർ നമസ്കാരം.
നമസ്കാരം.
വിനീത് സർ, വിനു വിനായനാണ്. നമസ്കാരം സർ.
Yes. Tell me. How are you?
സർ വിനു വിനായനാണ്.
മനസ്സിലായി.
താങ്ക് യു സർ.
Okay, thank you for watching my webinar class.
ഞാൻ ആദ്യം മുതലേ ഉണ്ട് വെബിനാറിൽ.
I see. Okay. Any doubt, anyone? Because the time is now up about 9:10. So 9 past 10. So let us just wind up the session, because I also have to just go and attend another one meeting. In fact, they were all just waiting for me. So if there is no much doubt again, then I'll just hand over the mic to our Santosh sir.
Sir, your class is very magnificent and your presentation is marvelous. And the time is over, and we shall arrange to communicate the decisions given by the great orator and senior advocate. നമ്മുടെ ട്രസ്റ്റിൻ്റെ ക്ഷണമനുസരിച്ച് ഇവിടെ എത്തിച്ചേർന്ന് വളരെ വണ്ടർഫുള്ളായിട്ട് ട്രയലിനെ കുറിച്ചും ബെയിലിനെ കുറിച്ചും അതുപോലെ തന്നെ ക്രോസ് എക്സാമിനേഷൻ, ശരിക്കും പറഞ്ഞാൽ സാറിൻ്റെ ക്ലാസ്സുകൾ ഞങ്ങൾ ഇനിയും പ്രതീക്ഷിക്കുകയാണ്. അഭിഭാഷക സമൂഹത്തിന് സാറിൻ്റെ ഈ പ്രാക്ടിക്കൽ എക്സ്പീരിയൻസ് വളരെ 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 ഗുണകരമായിട്ടുള്ളതാണ് എന്നത് ബോധ്യപ്പെട്ടിരിക്കും നമ്മളിവിടെ ഈ വെബിനാറിൽ പങ്കെടുത്തിട്ടുള്ള എല്ലാവർക്കും. ഈ ലാ ട്രസ്റ്റിന് വേണ്ടി അതുപോലെ നമ്മുടെ ഈ വെബിനാറിൽ പങ്കെടുത്ത എല്ലാവർക്കും വേണ്ടിയും ഞാൻ സാറിന് ഒരു ലാ ട്രസ്റ്റിൻ്റെ ഒരു ഉപഹാരം സമർപ്പിക്കുകയാണ്.
Thank you, Chairman of La Trust.
Thank you, sir. 2 മിനിറ്റ് കൂടെ അതൊന്ന്
ഈ ചടങ്ങിന് നന്ദി രേഖപ്പെടുത്തുന്നതിന് വേണ്ടി ദി ലോ ട്രസ്റ്റിൻ്റെ സെക്രട്ടറി അഡ്വക്കേറ്റ് പ്രേംകുമാർ അവർകളെ ക്ഷണിക്കുന്നു. ദി ലോ ട്രസ്റ്റിൻ്റെ ആഭിമുഖ്യത്തിൽ എല്ലാ മാസവും നടത്തി വരാറുള്ള ലീഗൽ അവയർനെസ് പ്രൊഫഷണൽ ഡെവലപ്മെൻറ്റ് വെബിനാറുകളുടെ ഭാഗമായി ഇന്നിവിടെ ബെയിൽ ആൻഡ് ട്രയൽ എന്ന വിഷയത്തിൽ വളരെ സവിസ്തരമായി സബ്ജക്റ്റ് ഓറിയൻറ്റഡായി നമ്മളോട് സംസാരിക്കുകയും അദ്ദേഹത്തിൻ്റെ എക്സ്പീരിയൻസ് നമ്മളുമായി ഷെയർ ചെയ്യുകയും ചെയ്ത പ്രഗത്ഭനായ അഭിഭാഷകൻ, സീനിയർ അഭിഭാഷകനായ അഡ്വക്കേറ്റ് വിനീത് കുമാർ സാറിന് ദി ലോ ട്രസ്റ്റിൻ്റെ പേരിൽ നിസ്സീമമായ നന്ദിയും കടപ്പാടും അറിയിക്കുന്നു. ദി ലോ ട്രസ്റ്റിൻ്റെ ചെയർമാൻ, നമ്മുടെ ഇവരുടെയും ഗുരുനാഥൻ കൂടിയായ അഡ്വക്കേറ്റ് ഡോക്ടർ സന്തോഷ് കുമാർ സാറിനും ഔപചാരികതയുടെ പേരിൽ നന്ദി അറിയിക്കുന്നു. ദി ലോ ട്രസ്റ്റിൻ്റെ സെക്രട്ടറി, ജോയിൻറ്റ് സെക്രട്ടറിമാർ, ടെക്നിക്കൽ എക്സ്പേർട്ട്, വൈസ് ചെയർമാൻ, മറ്റ് ലോ ട്രസ്റ്റിൻ്റെ മെമ്പർമാർ, അഭിഭാഷകർ, ജുഡീഷ്യൽ ഓഫീസേഴ്സ്, ലോ സ്റ്റുഡൻസ് ഉൾപ്പെടെ ഈ വെബിനാറുമായി ഓൺലൈനിലും ഓഫ്ലൈനിലും സഹകരിച്ച എല്ലാവർക്കും ഒരിക്കൽ കൂടി നന്ദി അറിയിച്ചുകൊണ്ട് നിർത്തുന്നു. നമസ്കാരം.